All rise for the President and judges of the
All rise.
Court of Justice.
Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. The following matters have been fixed for the delivery of its reserved judgment this morning, and they are as follows. 1. CCJ Appeal number 7 of 2019 between Zulfikar Mustafa versus the Attorney General of Guyana and the Chairman of the Election Commission. Can we have the appearance in this matter, please?
This is Jumalad. Mr. Douglas Mendez leads me, Mr. Mohamir Anel Nandalal, Mr. Marcel Nadir Sharma, Mr. C.D. Satram, instructor, and Candace Barat for Zulfikar Mustafa.
Please, Your Honor. Attorney General appears in person in association with Mr. Rutherford QC and Mr. Halbert QC.
The second set of matter, the consolidated judgments in CCJ Appeal number 9, 10, and 11 between Christopher Ram and the Attorney General of Guyana and the Leader of the Opposition and Joseph Harmon, between Bharat Jagdev and the Attorney General of Guyana and Dr. Barton Scotland and Joseph Harmon, between Charandas Prasad versus Compton Herbert Reed, Dr. Barton Scotland, the Attorney General of Guyana, Bharat Jagdev, and Joseph Harmon. Can we have the appearances for the court in these matters, please?
May it please Your Honours, Kamal Rampuran for the appellant Christopher Ram.
May it please Your Honours, Sanjeev acted in association with Mr. Stephen Singh and Ganesh Hira for the appellant Charandas Prasad.
May it please Your Honours, Neil Boston in association with Mr. Robert Corbin for Mr.
May it please Your Honours, in association with Mr. Rafi Khan, Senior Counsel for the respondent, Dr. Barton Scotland. May it please Your Honours, to inform the respondent, Joseph Harmon.
May it please Your Honors, the Attorney General appears in person in association with the Solicitor General, Mr. Nigel Hawk, Mr. Courtney, Ms. Iman Courtney, Senior Counsel.
May it please Your Honours, I appear on behalf of the added respondent, the Guyana Elections Commission.
Please, Jumalad, Mr. Mendez leads me, Davish Maraj, Mr. Mohamir Anel Nandalal, Mr. Marcel Nadir Sharma, Mr. C.D. Satram, instructed by Ms. Candace Barat for the Leader of the Opposition, Mr. Barat,
Yes, good morning, Council. This morning I would read summaries of the two sets of cases, and after I've read the second summary, we will then have a discussion about consequential matters. Before I read the first summary, which will be the Zulfikar matter, I just wish to place on record the court's deep appreciation to Ms. Misha Kelly, our Deputy Registrar, who is going to be soon leaving us. Ms. Kelly's the title of her position is Deputy Registrar, but it is a little bit of a misnomer. She actually functions in the same way that a registrar functions in other courts, because our registrar is actually the CEO of the court. Over the short time that she has been with us, Ms. Kelly has overseen, along with Mr. Hadial, the rollout of our courier software system and is an expert in that area. We are going to miss her very dearly. She has developed an enviable reputation among those whom she supervises, our Judicial Council, and the judges certainly will sorely miss her. So I wish to take this opportunity to wish her all the very best in the future. Case of Zulfikar Mustafa against the Attorney General and the Chairman of the Ghana Elections Commission. This case concerns the constitutionality of the appointment of Reverend Justice, retired, James Patterson, who was appointed on the 19th October 2017 by the President of the Republic as Chairman of the Ghana Elections Commission. The President made the appointment pursuant to the proviso of Article 161(2) of the Constitution. Mr. Mustafa, the appellant, complained that the process engaged by the President in appointing Justice Patterson was flawed. He asked the court to quash the appointment and to direct the President to choose one of the 18 persons who had been nominated by the Leader of the Opposition, Dr. Jagdeo, to that position of chairman. The Attorney General, on the other hand, has maintained that there was nothing wrong with the process and that Justice Patterson was properly appointed. Justice Patterson's appointment followed a series of written exchanges between the President and the Leader of the Opposition. These exchanges began in November 2016 and ran until October 2017. During that period, the Leader of the Opposition submitted 3 lists, each containing 6 nominees for the position of GECOM chairperson. The first list was rejected as being unacceptable within the meaning of the Constitution because, in the view of the President, the curriculum vitae of the nominees did not seem to conform to the requirements of the relevant constitutional provision. The second list was rejected by the President as he found it to be unacceptable within the meaning of the Constitution and also within the 4 walls of the criteria that he had set out in a statement of qualities of the chairman of GECOM, which statement he had submitted to the Leader of the Opposition. No specific explanation was given as to what made the list or the particular nominees named in it unacceptable. Prior to the submission of the third list, the government and the opposition issued a joint statement which provided, amongst other things, that the parties had met to consult, and I quote, on the way forward on the selection and appointment of the chairman. The parties also agreed that the chairman should be appointed without undue delay, unquote. The Leader of the Opposition submitted the third list, and the President, without providing explicit reasons, again disapproved this list as being unacceptable. The President then advised the Leader of the Opposition that he would have resort to the proviso, and Justice Patterson was then appointed. The decision unilaterally to appoint the chairman was justified on several bases. First, the President alluded to the discretion and power Article 161(2) granted to him. Reference was also made to the presidential immunity from court scrutiny under Article 182(1), which it was claimed empowered the President to act in his own deliberate judgment when exercising such discretion. Relying on those provisions, the President indicated that he had decided that it would not serve the public's interests to further delay the appointment of a chairman. The President also sought to rely on the July 2017 ruling of the High Court in Gaskin against the Attorney General, a case which had been decided after the second list had been rejected, but before the third had been provided. Before addressing the substantive issues in the case, the court considered certain preliminary objections made by the Attorney General. The court found that these objections had no merit and had been rightly overruled by the courts below. The court decided that the propriety of the chairman's appointment was a matter which could be inquired into because unless specifically ousted, the court has an inherent jurisdiction in matters relating to the interpretation of the Constitution. The court also held that it was its role authoritatively to settle what the Constitution means and whether some action taken by a constitutional actor is within or outside his or her constitutional remit. When a citizen raises legitimate questions that the appointment of the chairman of the Elections Commission may not have been in accordance with the Constitution, the court should not deny standing to such a person. Democracy and the rule of law are nourished by the posing of such questions and the court's answers to them. Mr. Mustafa, as a citizen, a registered voter, and a member of the National Assembly representing a non-governmental party, had sufficient interest to bring the application. The court considered that the essence of the case lay in the proper meaning of Article 161(2). To determine this meaning, the court looked at its drafting history. Under the 1980 Constitution, the Elections Commission chairman was appointed by the President in his own deliberate judgment from among persons who fulfilled certain defined eligibility criteria. This provision was modified in 1995 by Act No. 15 of 1995, which amended Article 161(2) and carved out a role in the appointment process for the Leader of the Opposition. This modified role of the Leader of the Opposition had been proposed by the Carter Center, which in 1990 had been invited by the then President Hoyt to observe the then upcoming elections. This proposal, which was known as the Carter Formula, provided for the submission by the opposition parties of a list of the names of 6 persons from among whom the then President Hoyt would select a chairman. The Carter Formula was eventually incorporated into the 1995 Act, which amended Article 161. This amendment, however, came to an end by virtue of a clause limiting its operation up to a specified date, and so the unilateral appointment under the 1980 Constitution was revived. In 1999, a Constitutional Reform Commission recommended, amongst other things, that, and I quote, "The chairman of the Electoral Commission should be full-time and should be selected on a consensual process," unquote, as provided for in the 1995 Act. This recommendation was adopted by the National Assembly and incorporated into the Constitution, Amendment Act No. 2 of 2000, with minor changes in the language. The court noted that the evolution of Article 161(2) had been characterized by a significant and deliberate shift from exclusivity and unilateralism on the part of the President to inclusion and consensualism as between the President and the Leader of the Opposition. The court examined Article 161(2) and noted that the first paragraph addresses in very specific terms the issue of the eligibility of candidates for the position of chairman of the Elections Commission. The Leader of the Opposition is required to submit to the President the names of 6 persons who satisfied the eligibility criteria, and the President is obliged to appoint one of the 6 nominees as the chairman. The article also provides that the listed persons must be, quote, "not unacceptable," unquote, to the President, and that in arriving at the list, the Leader of the Opposition is obliged to meaningfully consult with any non-governmental political parties represented in the National Assembly. The court found that while it was clear what was meant by meaningful consultation, as that phrase is defined by Article 232 of the Constitution, it was not clear what process should be followed to accommodate the spirit of consensus that must prevail between the President and the Leader of the Opposition. The court decided that the most sensible approach to operationalizing the article was for the Leader of the Opposition and the President to communicate with each other in good faith and perhaps even meet to discuss eligible candidates for the position of chairman before a list is formally submitted. The aim of these discussions should be to agree the names of 6 persons who fit the stated eligibility requirements and who are not unacceptable to the President. In this regard, the court noted that the Constitution anticipates that the Leader of the Opposition and the President will conduct themselves in a reasonable and responsible manner, eschew partisanship, and seek the best interests of the Republic and the Guyanese people. The court was also of the view that the employment of the double negative, not unacceptable, signals that an onus is placed on the President not to find a nominee unacceptable merely because the nominee is not a choice the President would have himself made. By a majority, the court found that the President should only find a nominee unacceptable for some good reason on objective grounds. If a President were permitted capriciously or whimsically, without proffering a good reason, to reject eligible nominees, this would frustrate the proper working of the Constitution. It would defeat the intention behind the amendment to Article 161(2), and it would pave the way for unilateral presidential appointment. The court found that once the President and the Leader of the Opposition have hammered out a list of names not unacceptable to the President, the list, comprising those 6 persons, must then formally be submitted to the President by the Leader of the Opposition, and the President must then select a chairman from among those names. In the court's view, such an approach gives the President a role in the identification of the 6 names, but obviates the possibility that after the formal presentation of the list, the President could suggest that one or more of the names, or indeed the entire list, is unacceptable. In those circumstances, a unilateral appointment by the President, in keeping with the proviso to Article 161(2), can hardly be an option if the Leader of the Opposition demonstrates a willingness to engage in good faith the process outlined above. The court reviewed what transpired between 22nd November 2016 and 19th November 2017, and the court determined that the President was not entitled to lay down as a precondition to considering a nominee eligibility requirements that were additional to or at variance with those prescribed by the Constitution. The court emphasized, however, that nothing in its judgment was intended in the slightest degree to cast aspersions on Justice Patterson's competence and suitability for the position of chairman of GECOM. Nor was there any suggestion that His Excellency acted otherwise than in good faith. Accordingly, however, in view of the unfortunate process that was followed, in view of the imposition on the Leader of the Opposition of criteria that were not sanctioned by the Constitution, and in view of the absence of cogent reasons for deeming unacceptable the candidates and lists provided, the court concluded that the process that was followed in the appointment of Justice Patterson was flawed and in breach of Article 161(2). In this regard, the court overruled Gaskin to the extent that the judgment in that case was in contradiction with anything that was stated by the court in this case. Justice Anderson, in a separate concurring judgment, agreed that the process followed in Justice Patterson's appointment was fatally flawed and did not comport with the constitutional requirements. While Justice Anderson agreed that the finalization of the list of eligible nominees should be through a process of consultation and dialogue between the President and the Leader of the Opposition, he was unwilling to find that at this stage, to impute into Article 161(2), there was a requirement to give reasons. He was of the view that deciding on the probity of the reasons given by the President as to why a person on the list was unacceptable to him was not a task that the courts ought necessarily to invite or be eager to undertake. He also found that the court should be slow to impose constructs which exert Lilliputian constraints on the policy discourse undertaken by the Republic's political giants, unless and until such constructs and constraints cannot be constitutionally avoided, unquote. Justice Rajnath Lee, in a separate concurring judgment, considered the historical evolution of Article 161(2) and the President's duty to give reasons. Justice Rajnath Lee found that Article 161(2) contemplates a consensual process whereby opposition political parties in Guyana will participate in a meaningful way in the selection of the chairman of GECOM. Further, given the modern trend towards openness, fairness, and transparency, and the historical background of electoral reform in Guyana and the amendments to Article 161(2) of the Constitution, there was a duty on the President to give reasons for rejecting the list submitted by the Leader of the Opposition. The giving of reasons by the President will ensure transparency and accountability to the people, avoid unilateralism and arbitrariness, and engender public trust and confidence in the elections process. Having regard to the foregoing opinions and conclusions, the Court intends to invite the parties to make submissions on the consequential orders that should be given by the Court. And that invitation, we will discuss when and how it will be taken up. This is a summary of the judgment of the Court in what I may refer to as the no confidence motion case. Article 106(6) of the Guyana Constitution states that the Cabinet, including the President, is required to resign if the government is defeated by the majority vote of all the elected members of the National Assembly on a vote of confidence. Article 106(7) further mandates that an election be held within 3 months of the vote, or within such longer period as determined by 2/3 of all elected members of the Assembly. On the 21st December 2018, the Leader of the Opposition moved a motion of no confidence in the government. All 65 members of the Assembly were present, and they all voted. Mr. Sharandas Prasad, a government member, joined the 32 opposition members in voting for the motion, so that 33 members ultimately voted in favor of the motion and 32 voted against. Despite this, the government did not resign, and no resolution was passed to prolong its continuance in office. Instead, litigation ensued. Mr. Compton Reed, a private citizen, sought a declaration that Mr. Prasad's vote on the no confidence motion was invalid because Mr. Prasad held dual citizenship at the time of his election to the Assembly in 2015, contrary to Article 155 of the Constitution. The Attorney General contended that the formula for achieving a majority of all elected members of the Assembly for the purpose of Article 106(6) was at least 1/2 of the members plus one. Utilizing this formula, he argued that 34 votes were required to pass the motion. Another private citizen, Mr. Christopher Ram, sought declarations that the motion had been properly passed by the 33 votes cast in the Assembly, and that national and regional elections were required to be held no later than 21st March 2019 in accordance with Article 106(7). Chief Justice Roxanne George found that a majority of all 65 members of the Assembly was 33 votes, as the formula required by Article 106(6) was simply one above the maximum number of potential opposers. She therefore held that the motion of no confidence had been validly passed. She further held that she had no jurisdiction to entertain the claim that Mr. Prasad's appointment was contrary to Article 155, as any challenge to his appointment had to be made within 28 days of his election to the Assembly, in accordance with the National Assembly Validity of Elections Act. Regardless, she held that Mr. Prasad's disqualification would not have invalidated his vote on the December 21st motion, as Article 165(2) of the Constitution preserved the validity of his participation in the Assembly's proceedings. The Court of Appeal unanimously upheld the Chief Justice's decision that the claim against Mr. Prasad's election could not be entertained and that his vote could not be invalidated.